been a quite fascinating subject for the student of law as well as the lawyers. But more so in view of the new act which has come into force, namely the Bharatiya Nagrik Suraksha Samhita, BNSS, what we call in short. We thought, what are the changes vis-a-vis the old act of CRPC and under the BNS? We requested G.Karuppasamy Pandiyan, an advocate from Madurai High Court and who is also a resource person in the Madras Judicial Academy, and he readily accepted our invite. We are thankful to him. Over to you, Mr. Pandiyan.
Thank you, Vikas sir, for your kind words. In fact, I'm very happy to come your platform, even though I'm taking classes in more platforms. But this is third time. The topic which is assigned to me is quite fascinating, as you rightly pointed out. Investigation. The term investigation, which have very much importance in a criminal case, as you know all. The investigation, which has been envisaged in chapter 13 of the BNSS. In CRPC, the investigation was has been envisaged in chapter 12. Almost all the sections are one and the same with slight changes, and some checks and balances are newly inserted in the BNSS. In section 173 to 196, which are all the sections, are covered in chapter 13. Now let us see what is the definition of investigation according to the BNSS. The section 2 class 1 class L tells about investigation, according to which investigation means it is nothing but collection of evidence conducted by a police officer or by any person other than a magistrate who is authorized by the magistrate in this behalf. So the definition what is available in CRPC is one and the same. It is like pari materia. So explanation class is added newly in the BNSS. What the explanation class says, if there is inconsistency as regards the investigation in between the special act and the Sankita, the special act shall prevail. This is what the explanation goes to say. However, the explanation also assumes importance in my humble view, because insofar as the investigation in normal criminal cases will differ from the special acts. Suppose investigation in PCR Act cases, there is a timeline. Investigation should have been completed well within the period of 60 days. However, there is no such timeline in normal criminal cases, so that this explanation also assumes importance. Now let us go to the sections, that is 154 in CRPC, 173 in BNSS. This section, in which some significant changes are made. Every information relating to the commission of a cognizable offence, irrespective of the area where the offence is committed, may be given orally or by electronic communication to an officer in charge of a police station, and if given. Here, one thing is very important. In CRPC, the information in cognizable offences is concerned, it was jurisdiction centric. Now it is not. According to the BNSS, that too section 173, irrespective of the area where the offense is committed. So the concept of zero FIR, which comes into the statute, and it has been legitimately recognized through section 173 of BNSS. Then 173 class 1 speaks orally it shall be reduced to writing by him under his discretion, under his direction, and be read over to the informant. And every such information, whether given in writing or reduced to writing as aforesaid, shall be signed by the person giving it. This is one and the same. The next section, the next provision, which is very, very important. By electronic communication, it shall be taken on record by him on being signed within 3 days by the person giving it. So the online complaint, the complaint can be made by electronic communication. So the online complaint, which has been statutorily recognized, provided when a complaint is given by electronic communication, the person who authors the complaint should come and sign the complaint within a period of 3 days. This is what the section says. In fact, one may ask a question: if the person is not able to come within 3 days, what will be the effect of? It is mere procedure. Suppose the complaint given through electronic communication, which is of serious nature, the investigation may go on without waiting for that. So this is procedure, as you know well, it is handmaid of justice. Next, let us see. Provided in the same section, proviso class. This is also very, very important. But what is available in the CRPC, the same is available now. The offences against women are concerned, the information relating to the offences against women shall be recorded by a woman police officer or any woman officer. This is one and the same. Then next proviso class is in the event that the person against whom an offence under section 64, 65, 66, 67, and etc. These are all the offences against women. In those offences, the person aggrieved is temporarily or permanently, mentally or physically disabled. Then such information shall be recorded by a police officer at the residence of the person seeking to report such offence, or at a convenient place of such person's choice, in the presence of an interpreter or special educator, as the case may be. So this is very, very important. And the 173 class 2, this is pari materia to section 154 class 2. A simple change is done, but it is assuming very importance, because this provision is relating to victim centric. A copy of the information as recorded under subsection 1 shall be given forthwith free of cost to the informant or the victim. So the copy of the FIR should be given at the free of cost, not only to the informant but also to the victim. Here the word is coined by the legislature, the informant or the victim. My humble view, instead of or, it should be and. Then the purpose will be served. And the third section, section 3rd, 173 class 3, without prejudice to the provisions contained in section 175 on receipt of information relating to the commission of any cognizable offence, which is made punishable for 3 years or more, but less than 7 years, the officer in charge of the police station may, with the prior permission from an officer not below the rank of deputy superintendent of police, considering the nature and gravity of the offence, proceed to conduct preliminary inquiry to ascertain whether there exists a prima facie case for proceeding in the matter within a period of 14 days. Here, I would like to uh, ponder over the uh, thing, that is prima facie case. This is new. In fact, as you all know, Lalita Kumari's case, that is Constitution Bench judgment, which is reported in 2014 to SEC page number 1. In the Lalita Kumari's case, the concept of preliminary inquiry, which has been coming to the fore. Now, the purpose for preliminary inquiry, according to the Constitution Bench of the Supreme Court, is only to find out the cognizable offence. However, in section 3, that is 173 class 3, a new concept is inserted, wherein it is stated preliminary inquiry has to be done to find out the prima facie case. It is something fishy. To find out prima facie case, we all know that prima facie case, that exercise should have been done by the judicial magistrate, and in the process of examination of witnesses, in the process of taking cognizance, this word assumes importance. Insofar as the prima facie case is concerned, this is very, very new, and this concept has been inserted in section 173 class 3. Moreover, the preliminary inquiry concept, though it is inserted in section 173 class 3, it goes contrary to the Constitution Bench judgment of Lalita Kumari's case. This is my humble view. And the second class, which says proceed with investigation where there exists a prima facie case. So, what is the standard of proof, or what is the degree level to find out prima facie case? That has not been given, and it is unexpected of from the police officer to arrive the subjective satisfaction as regards the prima facie case. Anyway, the cases where the punishment goes up to 7 years and more than 3 years, in those cases, the prima facie test has to be obtained according to the section 173 class 3. And further, 173 class 4, this is also one and the same. In 154 class 3, what it is stated, the same is available in 173 class 4. Any person agreed by the refusal on the part of an officer in charge of a police station to record the information referred to in subsection may send the substance of such information in writing and by post to the superintendent of police concerned, who, if satisfied that such information discloses the commission of cognizable offence, shall either investigate the case himself or direct an investigation to be made by any police officer subordinate to him in the manner provided by this Sankita. And such officer shall have all the powers of an officer in charge of the police station in relation to that offence, failing which, the word, please note it down, failing which such aggrieved person may make an application to the magistrate. So, if the complaint has been ignored by the officer in charge of the police station, we have an alternative remedy to send the same complaint to the SP of police in respect of district level, or commissioner of police in respect of the commissionerate level. Even then, the complaint, if ignored, the section 173 class 4 gives a remedy to approach the magistrate with application. So this provision, this new remedy, that is to approach the magistrate, has not been available in CRPC. That too 154 class 3 CRPC, it is not available. However, 173 class 4, where this new concept is inserted, in fact it is a welcome change. And the 174, the next provision, this is also very very important. 154 is pari materia to section 155, sorry, 174 BNSS, which is pari materia to 155 CRPC. Information as to non-cognizable cases and investigation of such cases. When information is given to an officer in charge of the police station of the commission within the limits of such station. In the previous section, that is 173, that provision, irrespective of any area, that word is coined. However, in 174, the complaint as regards non-cognizable offence is concerned within the limits of such station of non-cognizable offence. So now the 174 still remains as jurisdictional centric. He shall enter or cause to be entered the substance of non-cognizable offence. He shall enter substance of the information in a book to be kept by such officer in such a form as the state government may by rules prescribe in this behalf. And first class, refer the informant to the magistrate. There is no change at all here. The second class, wherein a significant change is made, in fact it is welcome change. Forward the daily report of all such cases fortnightly to the magistrate. Here, the forward the daily diary report of all such cases fortnightly to the magistrate. So the check is given, that is to the police officer. Then 174 class 2. 174 class 2 says no police officer shall investigate a non-cognizable case without the order of a magistrate having power to try such case or commit the case for trial. There is no change at all. 174 class 3. Any police officer receiving such order may exercise the same powers in respect of the investigation, except the power to arrest without warrant, as an officer in charge of a police station may exercise in a cognizable case. Here also no change. Then let us go to the next section, that is 175, which is pari materia to section 156 CRPC. Police officers power to investigate cognizable case. Any officer in charge of a police station may, without the order of a magistrate, investigate any cognizable case which a court having jurisdiction over the local area within the limits of such station would have power to inquire into or try under the provisions of chapter 14. Here, the proviso clause is inserted. This is new change. Provided, considering the nature and gravity of the offence, the superintendent of police may require the deputy superintendent of police to investigate the case. So this is new change. Normally, in a investigation can be done by the officer in charge of the police station. Now the change is where the SP may require the deputy superintendent of police to investigate the case considering the nature and gravity of the offence. This is new change. Then let us see the second proviso. No class 2, no proceedings of a police officer in such a case shall at any stage be called in question on the ground that the case was one which such officer was not empowered under this section to investigate. Here, this is very, very important. The explanation clause which attached to the definition of investigation will come into play. Here, no proceeding of a police officer in any such case shall at any stage be called in question on the ground that the case was one which such officer was not empowered under this section to investigate. Normally, in criminal cases, the section 175 class 2 will come into play. Insofar as the special act is concerned, for example, SCST Act, which specifically mandates the investigation should be done by the officer who is not below the rank of DSP of police. In such a situation, in those cases, investigation is done by the below ranking officer or the inferior level officers. That can be questioned. For our understanding, I am saying this. And section 175 class 3. 175 class 3 also a significant and welcome change has been done. Any magistrate empowered under section 210 may, after considering the application supported by an affidavit made under subsection 4 of section 173, and after making such inquiry as he thinks necessary and submission made in this regard by the police officer, order such an investigation as above mentioned. So the magistrate can order investigation based on the application received from the complainant. In such a circumstance, what is mandated through section 175 class 3 is supporting affidavit, which becomes mandatory. Even in the absence of the, the very provision, through the judgment of Honorable Supreme Court, that is Priyanka Srivastava versus State of UP, the Honorable Supreme Court of India mandates the filing of affidavit in all the applications seeking investigation under section 156 class 3. So the guideline, there was a specific guideline issued in such a case, that is Priyanka Srivastava versus State of UP 2015 6 SEC page number 287. So the guideline issued by the Honorable Supreme Court, now it has been inserted by way of an amendment, by way of a provision, specific provision. So this is welcome change. If affidavit is filed supporting with the complaint, then if any falsity, any false claim is made, the person who approaches the court can be made liable to be prosecuted under the case of perjury. So this is what, in some of the cases, the even if affidavit is filed, the person who approaches the court seeking direction for investigation would be doubly cautious. He would not submit the false claim. He would not make any unbelievable allegations. So that this is welcome change in my humble view. And section 175 class 4, any magistrate empowered under section 210 may, upon receiving a complaint against a public servant arising in course of discharge of his official duties, order investigation subject to A, receiving a report containing facts and circumstances of the incident from the officer superior to him. Then B, after consideration of the assertions made by the public servant as to the situation that led to the incident so alleged. Here, this is there are two separate classes are envisaged in section 175 class 4. The complaint as against the public servant is concerned. Section 175 class 4, which speaks of two specific classes. Insofar as the class A is concerned, receiving a report containing facts and circumstances of the incident from the officer superior to him, in my view, it is okay. The B class, after consideration of the assertions made by the public servant as to the situation that led to the incident so alleged. Here, impliedly, hearing audience is given to the proposed accused. This is nothing but sheer violation of the well settled canon of criminal jurisprudence. That I can say. Here, insofar as the complaint as against public servant is concerned, receiving a report containing facts and circumstances of an incident from the officer superior to him can be asked for. Insofar as the assertions made by the public servant, under what circumstance the situation lead him to take such a decision in the incident. Anyway, it is available in the statute. This privilege has not been given to the normal accused. It is given to the public servant when he becomes a proposed accused in a complaint which is given by the complainant. This privilege is given. So here I can say one thing. There was a cleavage of opinion in the even in the Supreme Court, while taking cognizance, while ordering investigation as against public servant, whether sanction is required or not. That was the question already decided, already that was referred to full bench in Manju Surana's case. You all know that the Manju Surana's case, 2018, 5 SEC, page 557. Now, because of the section 175 class 4, the impliedly the reference becomes nullified. So, while ordering investigation as against public servant, the two criteria, that is 175 class 4 A and B, which are required. That being so, the reference as regards ordering investigation as against public servant, whether sanction is required or not, becomes authorized. And let us go to the next section. Section 176 BNSS and 157 CRPC. Procedure for investigation. If procedure for investigation is concerned, the almost there is no change in the section compared than CRPC, but small changes are made. 176 BNSS, second proviso class, Srivastava citation 2015 6 SEC, page 287. Insofar as the procedure for investigation is concerned, the proviso class wherein a small change is made, wherein the statement of the victim can be recorded through any audio, video, electronic means, including mobile phone. This is welcome change because mobile phone is being the gadget. It is available in all of the person's hand, almost. So the victim statement, if it is recorded through mobile phone in the name of electronic audio video, it will be the first information. Then it can be the mobile phone is the gadget. It is available very casually in all the hands, so that the permission, the conferring power to the investigation officer to record the statement through audio, video, electronic means, including mobile phone, is welcome change. And section 176 class 2, here also uh, a check is given in each of the cases mentioned in classes A and B of the first proviso to section subsection 1. The officer in charge of the police station shall state in his report the reasons for not fully complying with the requirements of that subsection by him, and forward the daily report fortnightly to the magistrate. In the cases mentioned in class B of the said provision, the officer shall also forthwith notify the informant, if any, in such manner as may be prescribed by rules made by the state government. So, procedure for investigation, that point is concerned. If the investigation goes and the positive final report is filed, in those cases, the investigation officer is expected to forward the daily report fortnightly. Insofar as the B class is concerned, if it appears to the investigation officer or officer in charge of the police station, there is no sufficient ground entering on an investigation, he shall not investigate the case. This B class is concerned, the officer shall also forthwith notify the informant, if any, in such manner as may be prescribed by rules made by the state government. Here, the timeline is missing. If timeline is provided for the victim in the case where there is no sufficient ground, it will be better served. This is my humble view. And 176 class 3, let us go to section 176 class 3. This is completely new one. On receipt of every information relating to the commission of an offence which is made punishable for 7 years or more, the officer in charge of a police station shall, from such date as may be notified within a period of 5 years by the state government, in this regard, cause the forensic expert to visit the crime scene to collect the forensic evidence in the offense, and also cause videography of the process on mobile phone or any other electronic device. This is also a welcome change, but now the facility is not available. Even then, an alternative remedy is given in the same provision through proviso class. Let me read it. Provided that where forensic facility is not available in respect of any such offence, the state government shall, until the facility in respect of that matter is developed or made in the state, notify the utilization of such facility of any other state. So alternative is given. So the forensic expert is concerned, though the facility is not available, even the facility is not available, it can be availed of through the other state. That is what the section says. And let us go to the next section, that is 177 BNSS, which is pari materia to section 158 of CRPC. In this section, there is no change at all. It is one and the same. So let me read the section and I'll go. Every report sent to a magistrate under section 176 shall, if the state government so directs, be submitted through such superior officer of police as the state government by general or special order appoints in this behalf. Such officer may give such instruction to the officer in charge of a police station as he thinks fit, and shall, after recording such instructions on such report, transmit the same without delay to the magistrate. So this is one and the same. Likewise, section 178 BNSS also, there is no change at all. 178 BNSS, which is pari materia to section 159 CRPC, power to hold investigation or preliminary inquiry. Then let us go to the next section, 179 BNSS. In CRPC 160, this is very, very important. Police officers power to require attendance of witnesses. Here, almost the section is one and the same as that of CRPC, but a small insertion is made in proviso clause. Any police officer making an investigation under this chapter may, by order in writing, require the attendance before himself of any person being within the limits of his own or any adjoining station who, from the information given or otherwise, appears to be acquainted with the facts and circumstances of the case, and such person shall attend as so required, provided that no male person under the age of 15 years or the above age of 60 years, or a woman, or a mentally or physically disabled person. The change is this: a person with acute illness, this is a change, shall be required to attend at any place other than the place in which such person resides. So these are all the mentioned persons cannot be called upon to attend the to be required their attendance unless they have shown their willingness. The proviso clause is subsequently added in the new BNSS, provided further, if such person is willing to attend at the police station, such person may be permitted to do so. So these are all the persons cannot be called upon to attend the investigation, but the police officer or the officer inside the police station should go to their place and to examine them if they are acquainted with the facts and circumstances of the case. If they are willing to come and attend, they can be examined. This is what the section says. Section 180 BNSS and 161 of CRPC. Examination of witnesses by police. This is also one and the same. There is no sea change at all. Here, any police officer making an investigation under this chapter, or any police officer not below such rank as the state government may, by general or special order prescribed in this behalf, acting on the requisition of such officer, may examine orally any person supposed to be acquainted with the facts and circumstances of the case. Here, I would highlight the word any person. Any person. The police officer can examine any person. Any person, which means it includes accused. There was a question whether the term any person which would include accused or not. This was answered by Justice V.R. Krishnaiyer in the case of Nandini Sadbadi. So this is well settled. The accused person also can be examined by the police because he is acquainted with the facts and circumstances of the case. Class 2. Such person shall be bound to answer truly all questions related to such case put to him by such officer other than the questions answers to which would have a tendency to expose him to a criminal charge or to a penalty or forfeiture. So in those questions, if that questions in which the accused is ready to answer, if it exposes him criminally charged or tendency to incriminate, for that he is not bound to answer. And section 3, 180 class 3, the police officer may reduce into writing any statement made to him in the course of an examination under this section, and if he does so, he shall make a separate and true record of the statement at each such person whose statement he records, provided the statement made under this subsection may also be recorded by audio, video, electronic means. And more proviso clause is there which speaks of the offenses against women in which the person aggrieved by the document shall be recorded only by the human officer. This is what proviso clause 60. The next section, section 182. No inducement to be offered. Here also there is no change. Section 183. Recording of confessions and statements. Here, recording of confession and statements is concerned. One 64 A class 6 of CRPC. The same way here a proviso class is inserted. According to that proviso class, the search conducted under this section shall be recorded through audio, video, electronic means. Audio, video, electronic means. And let us go to the next section. 184 of BNSS. Medical examination of victim of rape. Here, a timeline is provided. 24 hours timeline is provided, where during the stage when an offense of committing rape or attempt to commit rape is under investigation, it is proposed to get the person of the woman with whom rape is alleged or attempted to have been committed or attempted examined by a medical expert. Such examination shall be conducted by a registered medical practitioner employed in a hospital run by the government or a local authority, and in the absence of such a practitioner, government or local authority, by any other registered medical practitioner with the consent of such a woman or of a person competent to give such consent of her behalf, and such woman shall be sent to such registered medical practitioner within 24 hours. Before that, there was no timeline. Now the timeline is prescribed. The victim should be brought to the medical practitioner within 24 hours. And section 185. Section 185 BNSS, which is equal to 165 of CRPC. Here, search by police officer. (185) class 2, where a proviso clause is inserted. A police officer proceeding under subsection 1 shall practicable conduct the search in person, provided that the search conducted under this section shall be recorded through audio, video, electronic means, preferably by mobile phone. So the audio, video, electronic means, which is preferably by mobile phone. So mobile phone now becomes very important in the course of investigation, that can be used to record the video or to record the statement of victim. So the audio, video, electronic means in which mobile phone is included. And section 185 class 5 is concerned. 185 class 5. This is very important. Copies of any record. Copies of any record made under subsection 1 or subsection 3 shall forthwith, not later than 48 hours, be sent to the nearest magistrate empowered to take cognizance of the offence. So not later than 48 hours, the copies of records shall be sent to the nearest magistrate. Then let us go to the next section, 186 of BNSS. When officer in charge of police station may require another to issue search warrant. This is also one and the same. There is no change at all. And section 187, this is very important. Section 187 is pari material to section 167 of CRPC. Here, procedure when investigation cannot be completed in 24 hours. The magistrate 187 class 2, where there is a significant change. Let us go into this details. The magistrate to whom an accused person is forwarded under this section may, irrespective of whether he has or he has no jurisdiction to try the case, after taking into consideration whether such person has not been released on bail or his bail has been cancelled, authorize from time to time the detention of the accused in such custody as such magistrate thinks fit, for a term not exceeding 15 days in the whole or in parts at any time during the initial 40 days or 60 days out of detention period of 60 days and 90 days. So, as you all know, there is still a conundrum as regards police custody. Whether the 15 days custody, where from it starts, and whether the police custody can exceed the 15 days. These are all the questions still uh, coming. Here, the section is very, very clear. So, the police custody can be given not exceeding 15 days in the whole or in parts. So, this concept should be considered with the concept of statutory bail. In case the 60 days, 90 days concept you know well, insofar as the offences which prescribe the punishment up to 10 years are concerned, the charge sheet should have been filed within a period of 60 days. And insofar as the other offences which prescribe the punishment more than 10 years up to life or death, in those cases, the charge sheet should have been filed within a period of 90 days. If not, the accused is entitled for statutory bail. So, the 60 days, 90 days concept we should bear in mind. When that being so, it would be easy for us to see the term not exceeding 15 days in the whole or in parts at any time during the initial 40 days in respect of 60 days prescribed time limit cases are concerned, the police custody can be given only for 15 days, either as a whole or in parts, up to 40 days. The cases where the punishment prescribed more than 10 years up to death, in those cases, the police custody can be sought for only for the period of 15 days that can be stretched up to 60 days. Let me say like this: 15 days custody alone can be given, but such 15 days can be given in parts: 5 days, 2 days, then 3 days. This can be stretched up to the time limit of 40 days in cases where the offences prescribe the punishment up to 10 years. The other cases where the punishment prescribed more than 10 years, in those cases, 15 days custody alone can be given, but it is not as stated by Anubham J. Kulkarni's case. The Anubham J. Kulkarni's case, where the Supreme Court held that from the 15 days, not exceeding 15 days from the date of first remand. This is what the judgment says. But CRPC never says so. Never says so. BNSS also does not say so. Not exceeding 15 days is the limit. But in infraction, 5 days, 5 days, because in first 15 days, the police is not in a position to take police custody of the accused. The investigation cannot be completed. Suppose accused was not in a position to speak. If he is admitted in hospital in the first 15 days, the police or the investigation power will be of no use. So to alleviate that situation, section 187 class 2 has been very clearly uh, stated, as if a term not exceeding 15 days in the whole or in parts at any time during the initial 40 days or 60 days out of detention period of 60 days 90 days. I hope that everyone would understand. So this is the thing. But somebody may say that because of the stretch of the period, because of the uh, long rope to the investigation agency, bail will be deprived of. Somebody may feel, somebody may say. I am saying that it is not. Because let us go to section 480 of BNSS. Section 480 of BNSS, and there is a particular proviso clause which says that 480, which speaks of bail, provided also the mere fact that an accused person may be required for being identified by witnesses during investigation or for police custody beyond the 15 days shall not be sufficient ground for refusing to grant bail if he is otherwise entitled to be released on bail. So this is very, very important. Merely because the police custody beyond the 15 days shall not be sufficient ground for refusing to grant bail if he is otherwise entitled to be released. So this is very, very important. And let us go to the other section, 188 BNSS. 188 BNSS is concerned, there is no change at all. Report of investigation by subordinate police officer. And next section, release of accused when evidence deficient. Here also there is no change at all. And section 190 of BNSS, cases to be sent to magistrate when evidence is sufficient. Here 190 BNSS, which is equivalent to section 170 of CRPC, here a proviso clause is inserted. Here also it is a welcome change. This is a change which came from the judgment of Honorable Supreme Court. Let me read the particular proviso clause alone. Provided that if the accused is not in custody, the police officer shall take security from such person for his appearance before the magistrate, and the magistrate to whom such report is forwarded shall not refuse to accept the same on the ground that the accused is not taken in custody. So, the in case where the accused is not arrested, however, investigation was over, charge sheet is investigation is over, charge sheet is filed. At the time of filing charge sheet, there according to section 170 of CRPC and section 190 of BNSS, forward the accused. The term is uh, there. The term is often misconstrued by police. So that the Supreme Court, in the judgment, namely Siddharth versus State of UP, 2021, 1 SEC, page number 676, wherein the Honorable Supreme Court says, forward the accused, which does not give license to the police to arrest, or does not give license to the magistrate to remand the accused. This is what the Supreme Court says. The saying of the Supreme Court, which has been taken note of in the BNSS, and a proviso clause is specifically made. So, in those cases, when the accused is not arrested during investigation, even then the police can seek the security or surety from him. By stating so, the report can be filed. This is what section 190 BNSS says. That apart, there is no change at all. And insofar as the next section, that is 191 of BNSS is concerned, there is no change at all. Complainant and witnesses not to be required to accompany police officer and not to be subject to restraint. Here also there is no change. And then let us go to section 192 BNSS. Diary proceedings, diary of proceedings in investigation. This is 172 CRPC, 192 BNSS. Here also there is no change, but recently a judgment which came from the Karnataka High Court, namely Mohammed Shayab versus NIA. In that case, a direction was sought from the court to the investigation officer in all criminal cases, and he is to put signatures, he is to put initials in all the pages of case diary. By stating so, a direction was sought for. The Karnataka High Court declined by stating that neither statute nor rules prescribe such a practice, so it cannot be issued with. So, in case of case diary, signature of investigation officer in all pages need not be, and it cannot be directed. This is what the Karnataka High Court recently said. And the case diary is concerned, there is some confusions. General diary, station diary, police diary, case diary. These are all the terms which have been used, particularly in the criminal side practice. Here, the problem has been set at rest by the Honorable Madras High Court, that to Division Bench, 2019, 2 Law Weekly Criminal, page number 161. P. Kalaiselvam versus State. P. Kalaiselvam versus State. Wherein, in that case, peculiarly, the case diary was sought for through Right to Information Act, and that was obtained by the accused, and the same was marked. So the court heavily come down. It should not be, because the case diary is not an evidence. it can be made use of by the courts to aid into the trial, and the investigation officer can use of to refresh their memory. Unless and until this cannot be called upon either by the accused or by his agent. So this is the settled law. In Kalaisellam's case, the Madras High Court very clearly distinguished the diaries, general diary and station diary, which are one and the same. General diary, station diary, which is governed by Section 44 of Police Act and Section 706 and 707 of Police Standing Order. However, police diary and case diary, which are one and the same, police diary and the case diary, which are governed by Section 172 CRPC. So, this cannot be sought for by the accused. This cannot be marked as evidence. So, this is very, very important. P. Kalaiselvam versus State, 2019, 2 Law Weekly Criminal, page 161. And let us go to section 173 CRPC, 193 BNSS. 193 BNSS is concerned, the final report, which can be, now we are, now the practice is that final report is being filed through online portal. It is permissible because of the section 193 class 3. So e-filing of final report becomes legitimately permissible. Let me read the particular section 193 class 3. As soon as the investigation is completed, the officer in charge of the police station shall forward, including the electronic communication, to a magistrate empowered to take cognizance of the offence on a report in form of the form as the state government may by rules provide stating. So the final report can be filed through e-filing. And 193 class 2, there is a slight change. Insofar as the offences against women are concerned, the investigation shall be completed within a period of 2 months. In CRPC, the timeline was 3 months. In BNSS, the timeline that is given to 2 months. Except these offences, there is no timeline for completion and investigation in any other offences. So, the offences against women are concerned, investigation shall be completed within a period of 2 months. Then 173 class 3, class 1 and 2, which are very, very important. The sequence of custody in the case of electronic device. Then the police officer shall, within a period of 90 days, inform the progress of the investigation by any means, including through electronic communication to the informant or the victim. So, normally the victim will be kept at the bay. Now BNSS gives importance and gives audience to the informant so that the within 90 days the progress of investigation shall be informed to the victim. This is what section 193 class 3 class 2 says. And 170 173 class 8 and 193 class 9. Here also it is very very important. A proviso clause is inserted. So further investigation, the term further investigation and re-investigation, which is always uh, used, this is the terms we come across almost daily. So insofar as the further investigation is concerned, as you all know, as per section 173 class 8, the further investigation can be ordered by the jurisdictional magistrate. Here, a proviso clause is given, wherein further investigation during the trial may be conducted with the permission of the court trying the case, and the same shall be completed within a period of 90 days, which may be extended with the permission of the court. So in this regard, a judgment, recently a judgment came from so further investigation is concerned, a permission from the court is required. This is what the proviso clause says. In this regard, one 93 class 9. I'll give the citation later. According to the judgment, the permission of the court is very much required while seeking further investigation, that too during trial. And the further investigation should be completed within a period of 90 days. And the same can be extended with the permission of the court. This is what section 193 class 9 says. So further investigation, re-investigation, that can be ordered only by the re-investigation is completely different from further investigation. Further investigation can be ordered only by the jurisdictional magistrate and any other court. Insofar as the re-investigation is concerned, that can be ordered only by the constitutional courts, that is High Court and Supreme Court. So re-investigation cannot be ordered by the jurisdictional magistrate. And one more point is, further investigation cannot be ordered by the superior police officer or home secretary. In two occasions, the Supreme Court heavily come down. In one case, that is Peethamparan versus State of Kerala. In that case, further investigation was ordered by the district police chief in the Kerala state. That practice was deprecated in the judgment, namely Peethamparan versus State of Kerala, 2023 SA or criminal, page number 612. And the other case, And the other case is Bohati Devi, Bohatie, Bohati Devi versus State of UP, 2023, SAR Criminal 719. In that case, uh, State Home Secretary ordered further investigation, and that case taken up to Supreme Court, wherein Supreme Court heavily come down by stating that that power is not available to the Home Secretary or any other person rather than the jurisdictional magistrate under Section 173 Class 8. This is what Supreme Court held. So this is very, very important. And in one case in which executive magistrate uh, ordered investigation based on 156 Class 3 petition. This practice was also deprecated by the Supreme Court in Norman Singh, NAMAN, Norman Singh versus State of UP, 2019, 2 SEC, page number 344. In that case, the Supreme Court categorically stated any magistrate empowered under Section 190 CRPC alone can order investigation. That does not include executive magistrate. And the next section is (194) BNSS, 174 CRPC, in which there is no change at all. And power to summon persons, Section 195. In that case also there is no change. In that provision also there is no change at all. Insofar as the 194 of BNSS, in that section a timeline is framed. The inquest report, that is, the report shall be signed by such police officer and other persons, or by so many of them as concur therein, and shall be forwarded to the district magistrate or the subdivisional magistrate within 24 hours. This is what Section 194, Class 2 says. With this, let me conclude the class. So, investigation chapter almost we have seen, and the changes also I have stated, hopefully.
In fact, I had shared the video on the WhatsApp group. A lot of people have liked the way you have shared your knowledge, and thank you for sharing your knowledge. And
Any other questions?
no, there's no question. And thank you, everyone. Stay safe, stay connected, and thank you, Mr. Pandiyan, for sharing your knowledge. Thank you.
Thank you, sir.